Hi guys! Welcome to another episode of Atty. Vlogger. Today we take up part 5 on the law of contracts. We continue with the defective contracts and focus on the voidable contracts, okay? Not to be confused with the void contracts, we are taking up voidable contracts, okay? So if you like my videos and you want to see more, please hit the subscribe button. Please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? So what are voidable contracts? These contracts are valid. Why? Because all essential elements necessary for validity are present, namely consent, object, and cause. Okay? So these contracts are valid, but they are defective. Why? Because either one of the parties is incapable of giving consent, such as the case of a minor, insane person, or a deaf mute who does not know how to write, or there is a vitiation of consent, or there is a defect or vice in the consent consisting of mistake, violence, intimidation, undue influence, or fraud. We'll take that up later, no? Okay. Now, these voidable contracts are valid, as I said, but they are valid until they are either annulled or ratified. Now, let's take a moment to talk about annulment and ratification, okay? What is annulment? Annulment is a remedy allowed by law for the declaration of inefficacy of the contract, meaning the contract is no longer effective, okay? Based on the defect of consent, and with the effect of restoring the parties to their position prior to the perfection of the contract. Okay? So who can bring this action for annulment? No? The law says that only the parties either principally or subsidiarily liable under the contract may bring an action for annulment. Okay? Now, the important thing to remember is whether he is principally or subsidiarily bound under the contract, the only party who can bring an action for annulment is the injured party. Okay? The law will not allow the party at fault to claim annulment. Why? Because he is the one who caused the defect in consent. He is the one who caused this whole mess. So the only one who can bring an action for annulment is the injured party. Okay? So much so that in case there is a party who is capacitated or has capacity to act, and he contracts with a party who is incapacitated, such as a minor or insane person, okay? The party who is capacitated is not allowed to allege or use the fact of incapacity against this incapacitated person, okay? Because necessarily he will be acting in bad faith. So the rule is parties who are capacitated cannot allege the incapacity of the parties with whom they contract. Okay? Now, just to make it easy, no? Who can bring an action for annulment? All that is required is first, that person must be interested under that contract. He has an interest in the contract. And second, he is the injured party. Okay? Okay. And what is the effect of or consequence of annulment? No? It is the duty of mutual restitution. Under this duty of mutual restitution, the parties are obliged to return whatever they may have received by virtue of the contract. So for instance, a party is bound to return the object and its fruits in case he has received them, while the other party is bound to return the price and its interest in case he has received them. Now, the law says that the action for annulment is extinguished or is no longer available in case the thing or object of the contract is lost due to the fraud or fault of the injured party. Okay? In case it is the fraud or fault of the injured party. So there is no more annulment in that case. Okay? Second case where there is no annulment or the remedy of annulment is not available is when either party cannot return what he has received by virtue of the contract. Okay? So the action now is simply one for damages and no longer annulment of the contract. Okay? Now we can move to ratification. Okay? What is ratification? It is the voluntary acceptance or adoption of an unauthorized act or contract, okay? Signifying the intent of a party to be bound to the contract. It is as simple as saying, okay, I am fine with this, let us proceed with what we have agreed upon. Or, okay ako dyan, tuloy na tayo. Okay? So, the things that are required or the requisites for ratification is first, the party giving ratification must have knowledge of the defect in the contract. Okay? Second is that such defect must have already ceased. Okay? In other words, it's no longer ongoing. And finally, the party giving ratification executes an act which implies his intention to waive his right to annul the contract. In other words, he can just nod his head, or he can give a thumbs up, or better yet, he expressly says, I am ratifying this contract, or I am okay with this, let us proceed. And what is the effect of ratification? It cleanses the contract from all its defects from the moment of perfection. Okay? If ratification is given, the contract is now clean. There are no more defects and it is now perfectly valid. Okay? Now we can go to the grounds of voidable contracts. First, when the parties are incapacitated to give consent. Okay? Now let's talk for a bit about incapacity. We have absolute incapacity, which is the topic for included in the topic for today, and those who are absolutely incapacitated are the minors, the insane or demented persons, or the deaf mutes who do not know how to write. But the law also gives us examples of relative incapacity and specific incapacity. Let's just go through that quickly, even though it's not under this topic. When we say relative incapacity, the incapacity to bind themselves in a contract is only in relation to specific persons or specific classes of property. An example in the law on sales is husband and wife cannot sell to each other except in case they have agreed on separation of property in the marriage settlement, or in case of a judicial separation of property. That's relative incapacity. Do not take that for voidable contract, because the rules in relative incapacity are different. And in case of specific incapacity, also in the law on sales, the incapacity here is in relation to the occupation of the person, or in relation to persons by reason of public order, public policy, morals, etc. Okay? Some examples, judges or lawyers in relation to things subject of litigation, or guardians with respect to the property of their wards, or agents with respect to the property of their principals. You learn this, or you may have learned this in sales. Okay? And again, the rules in relative or specific incapacity are different. Okay? They may vary. For today, we focus on absolute incapacity. So we focus on the minors, the insane or demented persons, and the deaf mutes who do not know how to write. Okay? Now, first with minors. Who is a minor? Anyone who is below 18. Okay? Because 18 is the age of majority in the Philippines. So, the rules on minors simply state that the minor is incapable of giving consent. But does that mean he cannot enter into a contract? No. He may enter into a contract through his parents, okay? Or his guardians, okay? Now, if the minor himself enters into a contract, there are certain modifications, okay? Such as in the case of necessaries, which are things such as food or other goods necessary for subsistence or living, In the case of necessaries, if the minor receives them, he must pay a reasonable price. Therefore, okay? Another example is when the minor enters into a life insurance, health or accident insurance, and the beneficiary is his estate or his father, mother, brother, child, or sister. Okay? In that case, the contract will be valid. Okay? So there are some modifications. But as a general rule, a minor is incapacitated from entering into a contract. and the minor himself or his guardian may bring the action to annul the contract. The minor himself may bring the action to annul or even ratify the contract, no? Within 4 years after the guardianship ceases or when he reaches the age of majority. Within 4 years from reaching the age of majority or 18. Okay? As to insane or demented persons, generally the contracts they enter into are voidable, but they may annul it or ratify it within 4 years from becoming sane. Okay? However, please take note that sometimes in insane or demented people, there are periods of sanity. Okay? These are called lucid intervals. And in case a contract is entered into during a lucid interval, then that contract is valid. Okay? Now, let's talk about deaf mutes who do not know how to write. Now, it is the burden of the party who contracted with them to prove that they understood the terms of the agreement. Okay? Now, why are these classes of persons incapacitated from giving consent? No? Because it is easier to commit fraud upon them, and the law simply wants to protect these individuals from fraud. Okay? Finally, contracts that are entered into in a state of drunkenness or during a hypnotic spell are also voidable. Okay? Now we can go to the vices of consent. Okay? The vices of consent are mistake, violence, intimidation, undue influence, or fraud. Okay? Let's first take up mistake. Now, mistake has two kinds. Now, we have mistake of fact and we have mistake of law. And as a general rule, the kind of mistake that serves as a ground for annulment is the mistake of fact. So, what is mistake of fact? It is a false notion or ignorance or lack of knowledge, which refers to either the substance of the thing, the principal conditions of the contract, or the identity or qualifications of the other party if it is the principal cause for entering into the contract. Okay? Substance of the thing, refers to the thing itself. No, the parties are mistaken as to the object of the obligation. Principal conditions. No, what is a condition? It is a future and uncertain event, the happening of which gives rise to or extinguishes rights. No, so if one of the parties was mistaken about the principal conditions of the contract, then it is also a ground to annul the contract. And finally, when we talk about the identity or qualifications of the person, that must have been the principal cause why the party entered into a contract, such as in the case of contracts of deposit or comodatum, where trust is an essential qualification. Okay, and if one party was mistaken about that qualification of the other party to the contract, then it may serve as a ground to annul the contract. Or when one of the qualifications was a certain skill set and the other party was mistaken about that skill set, it will serve as a ground to annul the contract. Okay? Now, mistake cannot be used to annul the contract if it refers merely to the incidents of the agreement, such as the ease of access to transportation. No? Mistake as to transportation, if not one of the principal conditions of the contract, will not serve as a ground to annul the contract. Motives also do not serve to annul the contract because motives are different from the cause of the contract. If you remember my discussion in my previous vlog, no? Please refer to the essential elements episode, no? And just to review, no? Motives will only serve to annul the contract if it predetermines the cause. Okay? Now, the mistake of fact must be substantial. In other words, the party would not have entered into the contract if he had known the true state of the facts, no? It must be the principal inducement why a party would want to enter into the contract. Okay? And in case one of the parties is unable to read and write, the party at fault has the burden to prove that the terms of the contract were read to the injured party and understood by the injured party. Now we can talk about mistake of law. Okay? As a general rule, mistake of law is not a ground to annul the contract. Why? Because under Article 3 of the Civil Code, ignorance of the law excuses no one from compliance therewith. Which is actually why I'm doing this series, no? Because it's free for anyone to watch, because everyone is supposed to know this anyway. Again, ignorance of the law excuses no one from compliance therewith. Okay? However, mistake of law may constitute a ground to annul the contract if it pertains to mutual error of the legal effect of the agreement. Okay? Now, the elements of the mistake of law to serve as a ground are, first, that the mistake must be mutual. Second, the mistake must refer to the legal effect of the agreement. And finally, it must frustrate the real intent or purpose of the parties in entering into the contract. One example is when one party transferred the possession of a movable thing to another party, understanding it to be a deposit, while the other party understood it to be a comodatum. Those are two different contracts, and both were mistaken as to the legal effect of the transfer of that movable property. In that case, there is a mistake in the understanding of the legal effect of the agreement, and the contract may be annulled. Okay? Now, mistake of law, in case of mutual error on mistake of law, is allowed as a ground to annul because even judges and lawyers disagree and cannot and sometimes have a hard time on doubtful and difficult questions of law. Okay? So the erroneous interpretation of a law will not be taken against a layman, in case of a doubtful or difficult question of law. Finally, the period within which to bring an action to annul the contract based on mistake is 4 years, okay, counted from the discovery of the mistake. With that, we can now move to violence, okay? In order for violence to be allowed as a ground to annul the contract, it must be serious and irresistible, okay? The law requires serious and irresistible force. In other words, it must be physical, which I will contrast later with the next ground, no? The law also allows the violence to be committed by a third person in order for violence to be invoked as a ground to annul the contract. So if a third person is involved, violence may invoke provided that there is connivance or conspiracy between the third person and the party at fault. Annulment based on violence may be brought within 4 years from the time the violence has ceased or ended. Okay? Now we can move to intimidation. If violence refers to physical, intimidation refers to mental. Okay? Now, the requisites of intimidation to be used as a ground to annul a contract would be, first, it produces a reasonable and well-grounded fear, okay, of what? Second, an imminent and grave evil, okay? Third, on the person of the other party, of the injured party, or of his spouse, ascendants, or descendants, or their properties, okay? Fourth, the intimidation must have been the cause why the injured party entered into the contract. Okay? So the intimidation here contemplates a threat. Now, one good example is a gun pointed at the head of the injured party. Of course, that is a reasonable and well-grounded fear that he might die. Okay? The fear is likewise imminent and grave. Okay? And the evil is committed upon the person of the injured party. But the law again allows it also on property as well as on the life and property of the spouse, ascendants, and descendants of the injured party. And finally, the gun against the head is the reason why the injured party entered into the contract. So let's say the gun is pointed at the head for the injured party to sign a contract. Okay? Now, please take note, when it comes to threats or intimidation, a threat to enforce a right or claim through legal processes is not contemplated under this article, okay? Such as a threat that I will sue you if you do not pay me your debt. Okay, that is all right. Because the party claiming the payment, no, is invoking the aid of legal processes. They are allowed by law. The intimidation contemplated under voidable contracts to serve as a ground must be of an evil which is either prohibited or not allowed by law. Okay? Now, to determine the degree of intimidation, the law says we can take into account the age, the sex, and other conditions of the parties. Okay? And finally, the period within which to bring an action of annulment based on intimidation is 4 years from the time that the intimidation has ceased or ended. Okay? Now, we can go to undue influence. Okay? Undue influence is simply taking improper advantage over the power, over the will of another. Okay? In other words, the other party possesses a higher moral ascendancy than the injured party. Okay? The injured party must have been deprived of his freedom of choice to such an extent that he is reduced to a mere automaton or robot, no? Na he has no other choice than to comply with the demand of the party at fault. Okay? Now, in order to determine if there is undue influence, the law says we can take into account the confidential, the family, or spiritual relations of the parties. We can also take into account the mental weakness or the fact that the injured party was under financial distress. Okay? Now, please take note, no? Undue influence does not apply if what happened was an act of kindness, affection, or argument. Okay? In other words, if the injured party agreed to enter into the contract because the party at fault was extremely nice, or extremely malambing and sweet, or convinced the injured party through logical, structured arguments, that's not a ground. That's not undue influence. Okay? The undue influence here contemplates an abuse of the power or authority or the moral ascendancy over the injured party. Okay? The period within which to bring an action for annulment based on undue influence is 4 years from the time the undue influence has ceased or ended. Okay? Now we can move to the last vice of consent, fraud. Okay? Now, fraud is insidious words or machinations used to wrest or obtain consent of the injured party to enter into the contract. Okay? It is misrepresentation in words or acts, okay, with a fraudulent purpose. Okay? But fraud may also take a different form. No, fraud also takes place in case of concealment. And what is concealment? It is the neglect or failure to disclose certain facts when there is a duty to reveal them. Okay? The concealment is important, like in a case of a contract of insurance, no? If a party has concealed material facts, no, it may be a ground to avoid or annul the insurance contract. Okay? So, concealment is the hiding of certain facts in case there is a duty to disclose them. Okay? However, if the concealment is unintentional, then the ground to annul the contract is merely mistake. Okay? If the concealment is unintentional. And if the concealment is intentional but there is no duty to reveal the facts, then both parties are bound to the agreement. You cannot have the contract annulled, okay? So the concealment must be intentional and it must refer to a material matter, and there is a duty to disclose those facts, okay? Now, there are two kinds of fraud. We have the causal fraud or dolo causante, and we have the incidental fraud or dolo incidente, okay? To render a contract voidable, the law has particular reference to the dolo causante, okay? Or the causal fraud. And what is causal fraud? It is the reason or the primary inducement to the injured party and why the injured party entered into the contract. Okay, it is the principal reason why the injured party entered into the contract. Okay, without which, the injured party would not have entered into the contract. Now, what are the requisites of causal fraud, or how do we know if it's causal fraud? Okay, first, there must be misrepresentation or concealment on a material matter with knowledge of the falsity of such material matter. Okay? So there's misrepresentation or concealment of a material matter with knowledge of its falsity. Second, okay, it must be serious. Okay? It is not merely slight deviations from truth. No? It must refer to the serious nature of the falsity, the importance, and not necessarily the influence on the other party. Okay? And third, it must only be by one of the parties. No? Fraud must not be exercised by both parties. The fraud must have been exercised by only one party to the agreement. Now, what if there is a third person? Then, if that third person connived or conspired with the party at fault, then that fraud is considered to be on the part of the party at fault. Okay? Fourth, there must be bad faith on the part of the party at fault or intent to deceive. Okay? The party at fault had intended to deceive or defraud the injured party. And finally, the fraud must be alleged and proven by clear and convincing evidence. Okay? Now, what's an example of causal fraud? I said, if you remember, it is the principal reason why the injured party entered into the contract. Okay? So, let's say we have here a person, X, He wants to buy a diamond ring to use as an engagement ring for his fiancée, So, he wants a diamond. Now, here comes Y, who sells him what appears to be a diamond ring, but really the diamond is made of glass. Okay? So, in that case, X entered into the contract of sale over the ring with the purpose of purchasing a diamond ring. He was defrauded by Y, who, knowing the fact that the ring was not made of diamond, but rather of glass, defrauded X. X now has a ground to annul the contract on the basis of causal fraud. Now, just so you will not be confused with incidental fraud, I will discuss incidental fraud as well. Okay? Now, incidental fraud is not a ground to annul a contract. Okay? Why? Simply because incidental fraud refers to fraud that is committed in the performance of the obligation. Okay? It only gives rise to an action for damages. Why? Because that incidental fraud was not present at the time when the parties agreed to enter into the contract. Okay? It was not used to obtain the consent of the injured party. Whereas causal fraud, discussed earlier, that is the fraud employed or exercised to get or wrest the consent of the injured party. It is the reason why the injured party entered into the contract. In incidental fraud, the fraud happens after the contract has been perfected. The contract is being performed, and that is when the fraud is committed. It only gives rise to an action for damages and not annulment. Okay? Now, what's an example? Let's say X is selling a house to Y. Okay? Y buys the house because he wants to live in the house that looks like that, because of its appearance and its amenities. Okay? X happens to mention to Y that, oh, this house is also nice because it's close to the MRT or public transportation. Y purchases the house saying that, oh, hey, it looks nice, I'll buy it, okay? Oh, it's good also that it's close to the MRT. In that case, if it turns out that the house is not actually close to the MRT because X has lied about it, then that is not such fraud as will give rise to an action for annulment. Y cannot annul the contract on that ground. He can only ask for damages. Why? Because the principal reason why Y wanted to buy that house was because of how it looked and because of the amenities, not because of it was being close to the public transportation. Okay? The nearness to the public transportation is only an incidental factor why Y may have entered into the contract, and it was not the principal reason why Y entered into the agreement. Now, the case will be different if Y is a commuter and relies on public transportation to go to the work, and he expressly tells X, I need a place that is close to public transportation so I will not be late to work. X says, oh, this house is near the MRT. Okay? And Y relies upon that statement as the principal reason why he enters into the contract. If it turns out that X lied about the house being close to the MRT, then that is the causal fraud which can serve as the ground to annul the contract. Okay? It is the cause or the reason why Y entered into the contract. Okay? So, the following, according to the law, are not fraudulent. No, we have the usual exaggerations in business and trade with the opportunity to know the facts. No, so when a person says, "Buy this bottle of water because it is the best tasting water in the whole world," you will know that that is merely an exaggeration. You cannot go to the person and say, "Hey, this is not the best water I've ever tasted." Okay, so that is a mere exaggeration in trade. That is not a ground to annul a contract. Second, the expression of a mere opinion. I think this is the best bottle of water. Okay? That is also not a ground to annul the contract. Except, okay, if the opinion is rendered by an expert and the injured party has relied on that expert opinion, and finally, if the opinion is false. In that case, the contract may be annulled on the ground of fraud, okay? Such as in the case of a jeweler. A jeweler is an expert on jewels, no? If the jeweler says that the diamond is a diamond when in fact it is glass, then an action for annulment may be brought against the seller of that diamond, okay? Now, misrepresentation by a third person is not necessarily fraud because the contract only takes effect between the two parties, no? But misrepresentation by a third person may be a ground for fraud if it caused mutual mistake between the parties. Both parties relied on the statement of the third person and they were both mistaken, okay? In that case, the contract may be annulled. Okay? And finally, in case of misrepresentation made in good faith, that is not a ground to annul the contract based on fraud, but is a ground to annul the contract based on mistake. So again, for voidable contracts, please just remember, voidable contracts are valid until they are either annulled or ratified. And how do you know if a contract is a voidable contract? You check first if the parties are incapacitated to give consent, such as a minor, insane, or demented person, or deaf-mute who does not know how to write, or the contracts entered into a state of drunkenness or hypnotic spell, okay? Or, in case of the vices of consent, mistake, violence, intimidation, undue influence, or fraud, okay? So that's it for voidable contracts. I hope you have picked up a thing or two. I'll see you in my next episode. Bye!